Today we are looking at the court structure in the United Kingdom. The United Kingdom is made up of 4 separate nations or home countries, effectively taking the form of regions: England, Wales, Scotland and Northern Ireland. At judicial level, both Scotland and Northern Ireland represent separate jurisdictions and each have their own court system, whilst England and Wales together make up another separate jurisdiction. However, the UK Supreme Court acts as the final court of appeal for all 3 jurisdictions. Now let's take a look at the court structure in England and Wales. Court jurisdiction in England and Wales is divided between criminal law and civil law, and the organisation of the courts follows this basic division. There is no separate administrative court system, as is the case in many civil law countries. It is important to note that the fundamental difference between common law civil law and common law criminal law is as follows. In civil law, a claimant, also referred to as a plaintiff or a complainant, sues seeking compensation for what has occurred. In criminal law, the state prosecutes the defendant in order to punish him and thereby deter further crime. The burden of proof in criminal law requires that the prosecution prove that the accused is guilty beyond all reasonable doubt. In civil law matters, the burden of proof is less high and the claimant is only required to prove his or her case on the balance of probabilities. Now let's take a look at the courts of criminal jurisdiction in England and Wales. Original criminal jurisdiction in England and Wales is exercised in the Magistrates' Court or the Crown Court, depending on the gravity of the offence involved. The Magistrates' Court, under the heading of minor or non-indictable offences, deals with the large majority of criminal matters. Serious crimes, referred to as indictable offences, also known as felonies in some common law jurisdictions, are tried in the Crown Court. Some indictable offences, known as triable either way offences, also known as dual offences or wobblers in some US states, allow the accused to choose between either a summary trial before the Magistrates' Court or a trial by jury in the Crown Court. By choosing to go before the Magistrates' Court, the defendant will probably receive a more lenient sentence and also save the state money and time, as it will not have to organise a jury trial. Appeals from the Magistrates' Court on questions of fact go before the Crown Court, whilst the Administrative Court, a specialist court within the QBD, i.e. the Queen's Bench Division of the High Court, deals with appeals on questions of law, or also called appeals on points of law. Appeals from the Crown Court on questions of law also go to the Administrative Court. Thereafter, an appeal on a point of law will be brought before the Supreme Court. Appeals on conviction or sentence from the Crown Court lie to the Criminal Division of the Court of Appeal. The Supreme Court does not hear appeals on conviction or sentence. Now let's take a look at the civil law courts in England and Wales. The civil jurisdiction trial court in England and Wales is the County Court, established by the County Courts Act of 1846. The County Court in England and Wales enjoys jurisdiction over disputes in most civil law areas, such as contract law, tort law, land disputes, family law, etc. County Court judges are either district justices, qualified to hear small claims, or circuit judges who hear more important matters. Appeals from decisions of County Court district justices are heard in the County Court by circuit judges. Appeals from County Court circuit judges are heard by the High Court or the Court of Appeal. As a result of the backlog of cases, a limited part of the County Court's civil jurisdiction has been transferred to the Magistrates' Court, which, as we have seen, is primarily a court of criminal jurisdiction. For example, areas such as debt collection are now heard in the Magistrates' Court. Family law issues such as maintenance and separation orders are heard in the recently established Family Court. The next level of civil jurisdiction is the High Court. The High Court has both first instance original jurisdiction for complex civil law claims and also appellate jurisdiction. At first instance, the High Court's original jurisdiction extends to civil law matters which will be heard in one of its three divisions. Actions concerning common law matters, for example, tort and contract law, are heard by the Queen's Bench Division of the High Court. Questions involving trusts, company law, etc. are heard by the Chancery Division of the High Court, and family law questions are heard by the Family Law Division. The Civil Division of the Court of Appeal hears appeals from the High Court, and decisions from the Court of Appeal may be appealed to the Supreme Court. Exceptionally, it is possible to appeal a case directly from the High Court to the Supreme Court by leapfrogging the Court of Appeal. This can occur if the Court of Appeal is already bound by precedent to rule in a certain way on the issue, and if the Supreme Court has already indicated its intention, through an obiter dictum, for example, to reconsider the precedent in question. In such circumstances, rather than bringing the action before the Court of Appeal, which will be bound by precedent as to the decision that it can take, the matter will be brought directly before the Supreme Court. However, the Supreme Court only hears appeals on questions of law of significant public importance, and the 12 justices of the Supreme Court, like their US Supreme Court colleagues, severely limit the number of appeals they hear. Now let's take a look at the jurisdiction of the courts of England and Wales. Civil law cases are categorized into different tracks on the basis of the amount of damages the complainant is claiming and on whether the case is complicated or not. First, there are small track claims, where the complainant is seeking less than £10,000 in damages, and where the action will be brought before the county court and dealt with under simplified procedural rules. Second category of civil action claims is called fast-track claims. The fast-track procedure applies to claims over £10,000 but less than £25,000. Again, simplified procedural rules are applied and expert testimony is limited so as to ensure that the matter is dealt with quickly, normally in 1 or 2 days. The final category of civil action is multi-track claims. This involves claims of over £25,000, where a case manager will be appointed and a decision will be taken as to whether the case, based on its complexity, should be heard in the county court or the High Court. Normally, only very complex cases are heard in the High Court. The High Court, sitting as the administrative court, also has a jurisdiction referred to as its power of judicial review, whereby it reviews the legality of decisions taken by tribunals and other local authorities and administrative bodies. In this role, it fulfills the function of a separate administrative court. And finally, there is a court in the UK that is called the Privy Council. The Judicial Committee of the Privy Council takes its origins from the circle of advisers on which the king relied on in medieval times. It is one of the oldest of the UK's institutions, and nowadays it hears appeals from the Supreme Court decisions of certain Commonwealth countries such as Bermuda, the British Virgin Islands, or the Cayman Islands. Now finally, I want to look at the relationship between the UK court system and the courts coming from European organisations such as the European Union or the Council of Europe. Now, as regards the European Union, there is no right to appeal at any stage of UK court proceedings before the European Union courts, which are only empowered to apply EU law and not UK law. However, Questions concerning the interpretation to be given EU law when a matter is before the UK courts may be referred to the EU Court of Justice for a determination pursuant to the Article 267 procedure of the Treaty on the Functioning of the European Union. Thereafter, the matter will be referred back to the UK trial court that made the interpretation request, and the UK court will then decide the case based on the interpretation it received from the Court of Justice. Now, as regards the Council of Europe and the European Court of Human Rights, appeals may be brought from the UK court system before the European Court of Human Rights in Strasbourg for issues arising under the European Convention on Human Rights, established by the Council of Europe in 1950. However, before an appeal may be brought before the Court of Human Rights, it is necessary that all UK domestic remedies be exhausted. We hope you enjoyed this summary of the court system in the United Kingdom.